Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Hello and welcome into the attorneys. Thank you so much for spending your Sunday evening with us. The next half hour, have a really interesting conversation headed your way. A couple of experts ready to dive into that. But before we do so, let's just kind of go over the ground rules here, just in case you are new with us tonight. At the bottom of your screen, you'll see ways that you can join our conversation, whichever is more comfortable for you. You can text, email, even call. There are actually attorneys standing by right now live from Hollis Wright, standing by to take your call. That is a free, off-air, and confidential conversation. So if you want some great free legal advice, the opportunity for the next half hour to take advantage of that opportunity. So be sure and take advantage of that. Leading our conversation, he's the managing partner of Hollis Wright, Josh Wright. Josh, how are you, sir?
I'm great, and I hope you're doing well.
I am doing well.
We actually are there, by the way.
We're there?
We're there. I mean, when people call, text, email, we're there.
People wonder about that.
They do. Sometimes they'll challenge us. Are you really there? We get texts. Are you really there? And we're actually there to answer questions. You know, look, and you said experts are here today. Yeah. Really, we have one expert, and our expert is Taylor Pruett. And we're going to be talking about wage and hour related issues. And when we have these types of issues, this is a very special area of the law that you've got to really understand the legal implications of how to be successful in these cases. And Taylor does a really, really good job with her group and with Alan Schreiber, one of her partners at the Alabama Wage and Employment Law Group. And so first of all, welcome.
Thank you, Josh.
Super happy to have you on to get into this area of the law. All right, so kind of lay this out for somebody who's watching right now. What's the show really about? Because this is a special area of the law and kind of specialty area of the law.
Yes, exactly, Josh. So this show is just kind of giving an inside scoop on wage and hour and things to look out for when you're an employee and you're maybe apprehensive about something that's going on with your salary each week or each month. And so it's just a little bit of background on the federal law, things to look out for, and just avenues to maybe pursue after the show if you still have questions.
Yeah, so what are the general kind of rules of the road in this area? I mean, does this fall under the FLSA? I mean, is that the federal labor that generally is applicable in these cases?
Yes, that's exactly right. So the FLSA that you mentioned, the Labor
Standards Act, yeah, that's
Labor
right.
Standards Act. Little stage right here.
You're doing
the
great,
FLSA, thank you. The FLSA is federal law, which regulates employers and employees, and so generally employers are required to pay their employees overtime for any hours worked over 40 in a single work week. And the FLSA does define work week as having starting any day of the week and at any time of the week.
So how does this apply, for example, for individuals that, you know, they classify as a manager that's responsible for managing people? Are they entitled to overtime? Like, we even see that at our law firm a lot of times, and we try and do everything we can to make sure we're complying with the law, to make sure that we're paying overtime to those that we need to pay overtime to, and if somebody isn't supposed to get overtime, that they don't get overtime because maybe they're salaried. I mean, that's a complicated analysis, isn't it?
It is, yes. And generally, like I mentioned, if you're working over 40 hours a work week, you are entitled to overtime compensation. There are a few exemptions from overtime. The three most common are the administrative, the professional, and the executive overtime exemptions. And so if you were to adequately fall under one of those, you would be exempt from receiving overtime.
So when someone comes in and says, all right, here's the circumstance at my job, I'm not getting overtime, but they're forcing me to work 60 hours a week, is there an analysis that you do to try and assess whether they're even eligible for overtime?
Yes, exactly. And so first, those three exemptions that I mentioned, we'll kind of run through those. And the most common are the administrative, professional, and executive. And so the administrative exemption is kind of the rarest of the three. The administrative exemption deals with an employee that has great authority within a business. They have the authority to bind a business or a company by setting policy and procedures. So these employees are typically insurance adjusters, human resource managers, office managers. And then we also will look to the professional exemption. Are you a professional? Does the employee have an additional degree or a specific area of expertise or acquired knowledge? And so these are typically doctors, lawyers, engineers, and architects. And then lastly, and in my opinion, the most used and abused exemption is the executive exemption. And so executive exemption is really important to look out for because oftentimes employers will use this exemption to escape the liability of paying their employees overtime compensation. So to be adequately classified under the executive exemption, your primary duty must be management. You must be managing a department or a business, and you must be supervising 2 or more full-time employees. So that's 80 hours a work week that you're supervising, and most of these employees are classified as managers.
All right, so you said you see that's one of the most abused exemptions. What do you see? I mean, is it that someone's qualifying somebody, giving them the title of manager, but they're actually not adequately managing? I mean, is that what you normally see?
Yes, Josh, that's right. Unfortunately, sometimes employees will think that just because they've been given the title of manager that they're exempt from overtime. And what they don't realize is even being classified as manager, there's certain qualifications that have to be met and criteria that has to be met in order to even be a manager. You have to be able to hire and fire. You have to be able to reprimand an employee and also set schedules. And then most importantly, and the most common violation we're seeing today is the full-time equivalent standard, the FTE requirement. And what this means is that a manager must, in every single work week, supervise 2 or more full-time employees or their equivalents. That's 80 hours of supervision every week.
If you questioned whether or not we have an expert in the house, we got an expert in the house. And this is why, I mean, and look, and Taylor will tell you, one of the complicated parts of these cases, because we've handled some of these cases in the past too, one of the complicated natures is the assessment that she just talked about. Because think about it from this perspective. We kind of just let's lay it out on the table. Why would an employer do this? Why would an employer qualify somebody as a manager and avoid paying overtime? It may not happen in a circumstance where you have one manager or just 2 managers in a business, but when you are a large entity, let's take a huge retail outfit, and you have thousands of folks that you can qualify as a manager and try and argue that they're supervising individuals, yet you don't give them hiring and firing authority, you don't give them the right to supervise and manage 2 individuals and the other things that Taylor mentioned, you're saving in overtime millions and millions of dollars every month. So a lot of times there are employers doing it 100% the right way, and I think Taylor would tell you that, but there are also employers that are pushing the bounds to try and save money and be more efficient and increase their bottom line by being smart and wise about, at least from their perspective, about what they're spending on their employees. And that's where lawyers have to evaluate these cases. It's tough.
I'm curious if the violations, and this is really just an opinion from you, the violations are you think they lean more to negligence, or is it just ignorance? I guess you could say not knowing that what they're doing is you can't do that.
Right, and that's a great question. That's something we'll have to look into with each individual case. But there are circumstances where unfortunately, the employer is just trying to save a little bit of money each week, and by classifying individuals as managers and having them work 60, 70 hours like Josh mentioned, that can be just kind of turning a blind eye.
Right.
So I know we're getting ready to go to break. Okay. When we come back, one of the things I want to talk about, because this is super important, is how am I compensated? And can I be discriminated against down the road if I've filed one of these lawsuits? But how am I compensated? How do I get that back over time? And do I get additional damages on top of that? Taylor's going to be able to handle that for us.
That's good. We'll step aside right here. We'll come back. More of the attorneys coming right up. Stay with us.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
The things you learn on this show. Welcome back in to The Attorneys. Thanks for being with us. A reminder before we head back into tonight's discussion, attorneys from Hollis Wright are standing by live right now. So if you have a question, take advantage of that opportunity. It is only available during the show. So about 15 minutes or so remaining. So take advantage of that opportunity. Josh?
All right, so Taylor, when we left, we were talking, kind of getting into damages. Explain to a viewer that may not be getting overtime what potential options they have for compensation and whether they can be discriminated against for filing such a suit.
Right, so I'll kind of break this down a little bit. First, I want to mention the statute of limitations for filing an unpaid wage and hour dispute. It's really important that you timely go see an attorney and discuss with them your options and have them look over your pay stubs to ensure that you are assessing the matter in a timely manner. So the statute of limitations for the wage and hour cases for Fair Labor Standards Act cases is 2 years, and so you'll have 2 years from the time you're wronged, from the time your salary is being tampered with, to go and find an attorney. In some very rare circumstances, you can go back 3 years if you can show that your employer was willfully denying you your compensation, but for the most part, you want to go see an attorney as soon as possible so you don't bar your opportunity to seek a suit and to recover your damages. So as far as damages, this is one area of law that's really important because you are recovering damages that you've already earned. You are recovering the money and the hourly wages that you've put in every single day. So for an overtime wage and hour dispute, you would be recovering your unpaid damages. And so an additional damage would be liquidated damages that you could pursue. And so liquidated damages is commonly referred to as double damages. So if your employer found, or excuse me, if your attorney found that you were still owed $7,500 with this suit, then with liquidated damages, you could double that and you could get $1,500 since your employer was not paying you overtime accurately. There are such thing as punitive damages where you can punish your employer for paying you incorrectly, but that's not commonly used and only a minority of courts will allow that. So you're really looking at the time you've already earned, those hours that you've put in, being compensated for that, and then potentially with liquidated damages, doubling that.
All right, so I want to unpackage a couple things from that, and then I want to get into the discrimination side of can you discriminate if someone files suit, because I know that will be an important issue. Let's unwrap a couple of these things. One, with reference to the statute of limitation, a lot of times what I have found is this is a continuing, ongoing wrongful conduct, maybe because the employer is ignorant that what they're doing is wrong, and the time is moving with the person. So really what's happening on the statute a lot of times, am I right that the 2 years is continuing to rotate, but you can only generally go back 2 years of lost wage? Is that fair?
That's correct.
Okay.
So if you came in today and saw an attorney and had a suit filed, you could only go back to October of 2016 for all of those wages. So if you worked somewhere for 10 years, unfortunately, you can't get the full 10 years. You could just go back from the date it's filed back 2 years.
In addition to that, let's talk for a minute, because I know this is a unique area of the law with the federal statute. How do the lawyers get compensated? Because I know there's somebody on the couch right now thinking, man, this is happening to me, but I don't know if I can afford a lawyer. The courts handle that, don't they?
So this is another very important topic to discuss, and in our firm, the way we do it, we'll have a free initial consultation where the employee can come in and speak with us and then we will only get compensated if the employee gets compensated. And so under federal law, under the Fair Labor Standards Act, the attorney is paid hourly. It's kind of different for plaintiff's work, but under the FLSA, you'll be paid hourly for the time you put into the employee's case, and then potentially on a contingency basis as well.
So there's it's a unique contract, something we don't normally see in the plaintiff world. But there is a way for the court to determine whether the employer is going to pay a portion of those damages, isn't
Yes,
there?
and that's correct. And everything will have to be, if you settle or take the case to trial, everything will have to be approved by the court.
So a person doesn't necessarily have to come to your office and just put a bunch of money up front.
No.
There's a process where you can represent them and give them the same quality of service that somebody would get on the employment side.
Yes, that's exactly correct.
All right, so talk with me just for a minute if we can. Dave, I'm sorry I'm monopolizing
I
our
love
conversation,
this.
but this is
It's
good
better when
stuff.
you guys talk,
No,
trust
Taylor's
me.
doing a good job.
Yep.
Talk with me on the punitive damage side. Are a lot of these issues that you're digging into about the employer's practice related to punitives and whether or not they willfully and intentionally did this, is it to find documentation, memos, those types of things to determine, hey, did you know what you were doing was wrong? Because if so, I may can convince the court that your conduct was willful. Is that how you handle it?
Right, and again, like I mentioned, punitive damages are pretty rare, at least in Alabama in the cases that I've worked on, but we will look and make sure your hours properly recorded. Did you have a timesheet? Were you clocking in and out? Is there anything that does show that you were working over, your 40 hours a week? Also, it's important to note anything with the Human Resources Department. Were there any complaints filed with the Human Resources Department regarding your compensation? What happened after a complaint was filed? And kind of going back to your a question a few ago, you asked about discrimination and bringing a lawsuit under the Fair Labor Standards Act. And it's important to note that your employer cannot terminate you because you brought a suit under the Fair Labor Standards Act. If they terminated you because you were alleging that they paid you incorrectly, down the road you could seek a wrongful termination case or a retaliation case. But by law, your employer cannot discriminate against you because you brought a lawsuit.
So there are protections against somebody that falls into that circumstance to allow them to make the decision and be confident enough to be able to go file that suit.
We have a couple of questions about lunch. Okay, and I'll just group them together and ask
I like
both of them.
questions about lunch.
I do.
Me too.
I love answers about lunch is what I love. What if an employer requires an employee to work through their lunch break? Okay, that's question one. The second question is, what if an employer automatically deducts an hour for lunch and you don't take that much time?
Great question, and these are two common violations that are arising in the Fair Labor Standards Act and wage and hour world. But so breaks and lunch are periods of time off where an employee is not actively engaged in the job. So the employer has said, okay, here's a lunch break, here's a break. You're not sitting at your desk, you're in the break room, you've gone to get lunch. But any time that you are at your desk, even if you're eating at your desk, you're to be compensated for that time. So if you are grabbing a sandwich or you're eating a salad while also answering phones and answering emails, you're to be compensated. And per Alabama law, there's actually no regulation that says an employer has to give a lunch break or an employer has to give a set number of breaks throughout the day. But with that being said, if you are working throughout the entire day, you're to be compensated for the entire day.
When we come back, I want to talk about a couple case examples that Taylor's had or that I've had and how complicated that they can be where the employer is engaged in conduct when they're really working the system to try and save money, because there's some good examples of that out there.
All right, look forward to that. We'll pick up right there whenever we head back. As we head to break, a reminder, a great resource for you is Hollis Wright and their social media game, Facebook, Twitter, as well as Instagram. Very educational and informational. Just search Hollis Wright and you'll find them all over social media. Stay tuned. We are coming right back.
I'm attorney Tyler Vale with the law firm of Hollis Wright. Many people ask the same question: why should I hire a lawyer? While there may be some legal situations that do not require you to hire a lawyer, the clear majority of legal problems would certainly benefit from having competent counsel involved. To begin with, the law is complicated. Even experienced lawyers typically do not represent themselves in court. A solid case with clear liability can quickly unravel without the help of a trained attorney. Lawyers understand the rules of evidence and know how to properly lay a foundation to get critical evidence and testimony admitted into court. Lawyers are trained to recognize legal problems early on in a case and can help avoid pitfalls that unrepresented individuals may fall into. Lawyers can also increase the value of a case by getting experts involved to help prove additional damages that an unrepresented person may not realize they are entitled to. An experienced lawyer has probably worked on cases like yours and can give insight to negotiating a fair settlement based on recent jury verdicts and settlements that unrepresented individuals may not have access to. Another important reason to hire an attorney is because the person or business you sue will likely have legal representation themselves. Non-attorneys are generally at a disadvantage when squaring off against opposing counsel or doing business with another party that has legal counsel. The law is complicated, and an attorney who is representing your adversary may try to take advantage of you. Our law firm offers free case consultations that allow you to meet with us for free during a face-to-face meeting, where we can discuss the type of case you have, the potential value of your case, and your likelihood of success. This initial meeting can help you decide whether you need to hire a lawyer. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys on WVTM 13.
Welcome back into The Attorneys. Just about 7 minutes remaining, so the clock is ticking. If you want to speak with one of those attorneys from Hollis Wright, standing by live, you got 7 minutes to do so, so pick up the phone and give them a call. Josh?
All right, so Taylor, let's talk a little bit. I want to have you assess a case for me, okay? Because this is a case that I had in the past, and then we'll talk through some of your stuff. All right, so an employer has 250 employees. Those employees have a degree that is a regular college degree, not an advanced degree, and they're not managing any individuals, and they're trying to claim the professional exemption on these individuals, forcing them to work 65 hours a week. How would you assess that case? Would you look at professional exemptions to start with?
Yes, I would immediately go to the professional exemptions and just everything that's outlined there. Like I mentioned, I mean, really you have to have an advanced degree, and this is a doctorate degree, this is a professional degree, or an area of expertise and acquired knowledge. So if you have, 200 plus employees that are all being classified under this, I'm not sure they would fit within that professional exemption well.
She wins. And you know what? She was right too. So a lot of times, I mean, what's complicated about this, and that was a very quick, easy example, but what's complicated, and Taylor can readily admit this, is, all right, so they probably don't meet a professional exemption because they don't have an advanced degree, right? Right. And they're not managing anybody, and they're not qualified as an executive, but they are making enough money hourly that it puts them above general thresholds for somebody that generally is going to be salaried, right? But that doesn't end the issue, because just because they're making enough money does not necessarily mean that they fit into one of the other executive or professional exemptions or administrative exemptions. And that was the issue we had, and why we ended up litigating that case for 3 years, ultimately got it resolved. But a lot of times it's complicated. I mean, it's not as simple. Someone says, hey, look, I'm making $750 a week. Well, that's above the thresholds generally for the FLSA, but you got to look at the other issues too.
Right, and that's the problem, is not looking at one of the exemptions or really the Fair Labor Standards Act in whole. That's where we run into a lot of issues with the classification of manager. You're classified as a manager, okay, executive exemption. Well, that's not entirely true, because under manager, there's all of this different criteria. There's supervision, there's hiring and firing, there's setting schedules and setting pay. And if you're not meeting the elements and the criteria of manager, then you're not meeting the elements and criteria of the exemption as a whole. And so one thing we've seen is employees that come in and they work most of the time by themselves. They're classified as a manager, and they work the majority, 65, 70% of their day by themselves. And so how are you supervising 80 hours a week if you're by yourself all but 3 hours of the day?
And I don't want to get too into this. There are some other exemptions out there, aren't there? Like,
there are.
I know we see in tractor trailer drivers, there are some examples where there's an exemption if you're an over-the-road driver, yet
Right.
if you're a yard dog and you only work inside Alabama or only work in a yard capacity, you may not have the exemption.
Right.
Those are all things that have to be evaluated, aren't
Yes,
they?
and there's some agricultural exemptions as far as farmers and sod layers. There's some exemptions with the Vehicle Motor Carrier Act. So that's just something, again, if you're apprehensive that something is not completely correct.
Other employment cases, you've got to, for example, put the EEOC on notice of a potential discriminatory action within 180 days of
Right.
that. Does the FLSA have similar requirements, or can you simply go to a lawyer and you got a 2 to 3 year statute?
You can simply go to a lawyer and you have the 2 or 3 year statute.
All right, we've got about 2.5 minutes remaining, so I want to give both of you ample opportunity. Just something to leave with our guest tonight, and if you would, you go first, please.
Yeah, I would say just the importance of contacting an attorney. It doesn't have to be me, it doesn't have to be the Alabama Wage and Employment Group, but just going and seeking out counsel if you're worried about your compensation. Like I said earlier, you're putting the majority of your day's time into work. You're working really hard, and that's time away from your family and your friends and time that you could spend on yourself. So make sure that you're getting everything you earned. I'm not going to employers and asking for anything that the employee hasn't already earned. So you have a right to that, and you have a right to be adequately and fairly compensated.
That's good.
So, you know, Alan Schreiber and I have been long friends, and Alan is kind of the one that started this Alabama Wage and Employment Law Group that Taylor's a part of now, and I'm glad they're branding that because it is a specialty area of the law. It's not something that everybody does, and it's a unique area of the law. And I think Taylor's exactly right. We spend more time, as you well know, in our business a lot of times than we do even at home. I spend more time at my desk on a typical day than I probably do sleeping in my bed. And when that happens, you want to make sure that you're fairly compensated. And I think Taylor's point is really well made, which is, look, nobody's asking for something that you aren't entitled to. But if you work the hours, you're entitled to those, and your employer has a responsibility and obligation to make sure that you're protected. The other thing I'd say is this, and I know Taylor has said this even today, there are plenty of employers that are doing it 100% the right way.
Right.
That's not what this case is about. This case is about circumstances where employers are doing it the wrong way because they're trying to work the system, or maybe they're ignorant and somebody needs to make sure that they understand, hey, you can't do it this way. It doesn't work that way. You need to protect your employers financially in these areas. And so this case really is more for the employer that is either innocently ignorant or is intentionally trying to work the system to save money. And our goal, you know, on this show is to make sure that we're protecting consumers and people that are out there, and especially those that are working. And the FLSA is a way to do it with folks like Taylor. So, first of all, awesome
Good
job.
job.
Thank you for having
You're
me.
good.
Great job.
Very good.
And what do you tell the folks who tried to call but have not spoken with an attorney standing by live?
Well, I mean, simple. We're around all week long, and all you have to do is call 844-LAW-TALK, or you can call, text, or email us all week long. We've got lawyers that are on the standby. And even if it's not related to this show, we can get you to a lawyer or answer your question related to
and
other
you
topics.
promise your attorneys, they return every...
We return every call, email,
Every
or
single
text.
call.
It takes time sometimes, but we do.
Yep. All right. Thanks so much. Thanks for being with us, and
Thank
thank you as well. We'll look for you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.